If you got hit by a semi or commercial truck in Florida, you're probably thinking one thing: the driver did this, so the driver pays. That sounds logical. It sounds fair. But in real truck accident cases, that assumption can cost you serious money. And in some cases, it can cost you the case. Here's why. Truck crashes are rarely just a, quote, driver problem. They're usually a chain of decision problems: a tired driver, a dispatcher pushing a deadline, a company skipping maintenance, a load that was not secured, a defective tire, a repair shop that cut corners. And if you only sue the driver, you might be aiming at the smallest insurance policy and the easiest scapegoat, while the real money and the real accountability sits higher up the chain. My name is Doug Burnetti, founder of Burnetti PA, and I've spent decades helping injured Floridians take on insurance companies and corporate defendants. Today, I'm going to break down 5 parties you can often sue in a Florida truck accident and what facts usually make each one liable. Let's jump right in. Before we list the 5 parties, you need one Florida rule in your head. Florida uses a modified comparative negligence for most negligence cases. That means if you're found to be more than 50% at fault for your own harm, you can be barred from recovering anything. If you're 50% or less at fault, your recovery can be reduced by your percentage of fault. That matters because trucking defendants love one strategy: spreading the blame. They will point at you. They will point at weather. They will point at another driver. They will point at a sudden emergency. So identifying all responsible parties does 2 things at once. It increases the available insurance coverage, and it prevents the defense from pinning the whole story on one person. Now let's build the liability map. Party 1, the truck driver. Yes, the driver is often the first obvious defendant. In Florida, if the truck driver was negligent and that negligence caused your injuries, you can sue the driver. What does negligent look like in trucking cases? Speeding, distracted driving, unsafe lane changes, following too closely, failing to yield, driving under the influence, or failing to stay awake. And fatigue is not justified, it's regulated. Federal hours of service rules limit how long property-carrying commercial drivers can drive. For example, the rules generally prohibit driving beyond a 14-hour on-duty window and limit driving time to 11 hours within that window after 10 consecutive hours off-duty. So, if a case involves a driver who had been on the road all day or the logbooks do not match the story, that's not just bad judgment. That can be a safety rule violation that helps prove negligence. Here's the practical point. Even if the driver clearly caused the crash, suing only the driver is often not enough to fully recover for catastrophic injuries. That's why truck cases almost always move to the next defendant. Party number 2, the trucking company. In many Florida truck cases, the trucking company is the most important defendant. Why? 2 reasons. Reason number 1, vicarious liability. If the driver was working, the employer can often be liable for what the driver did on the job under respondeat superior. And what respondeat superior is, it's a concept that says that while you're on the job, your employer is automatically responsible for what you do within the course and scope of your employment. The Florida Bar has discussed this principle in the commercial driving context, noting that when a driver acts within the scope of employment, the plaintiff may pursue the employer under this idea of respondeat superior. Reason number 2, direct negligence by the company itself. Even if the driver messed up, the company may have created the conditions for the crash, like hiring a driver with a bad record, failing to train or supervise, pushing unrealistic delivery schedules, ignoring safety complaints, allowing log violations, skipping maintenance. This is where the case gets bigger than the driver. Also, trucking companies often have higher levels of financial responsibility than an individual driver. Federal rules require minimum levels of public liability coverage for many interstate motor carriers, and the minimum can be $750,000 for non-hazardous property carriers with higher limits for certain hazardous materials. That matters because truck injuries are expensive. surgeries, rehab, missed work, long-term limitations. A personal auto policy is rarely enough. You may also hear the trucking company say, he's an independent contractor, talking about the driver. Sometimes that argument matters. Sometimes it's a smokescreen. A good trucking case looks past labels and digs into control, dispatch, policies, logs, and who actually benefited from the work done. That's how you expose the responsibility. Party number 3, the truck manufacturer or parts maker. Sometimes the crash is not primarily about the driver behavior. Sometimes something failed. The brakes, the tires, the steering, coupling systems, underride protection, lighting, even a defective part installed during repair. Florida recognizes product liability, including strict liability for defective products. The Florida Supreme Court adopted strict liability in products cases in West versus Caterpillar Tractor Company. What does that mean in real life? It means you may not have to prove the manufacturer meant to hurt anyone. The focus becomes whether the product was defective and whether that defect caused the injury. These cases get technical fast. They usually require engineer inspections and preservation of the failed part. But here's why they matter. If a mechanical failure contributed to the crash, the manufacturer or the parts maker can be a major source of compensation, and holding them accountable can prevent the same defect from harming someone else. If you hear things like tire separation, brake failure, steering locked, or the truck just wouldn't stop, that's a flashing sign to investigate a product or component claim. Party number 4, the company that loaded the truck. This one surprises people, but it's a huge category in Florida trucking cases. Cargo that shifts, spills, falls, or makes the truck unstable can cause rollovers, jackknifes, and chain reaction crashes. And cargo securement is not just a common sense, it's regulated. FMCSA cargo securement rules are designed to prevent cargo from shifting on or within a commercial motor vehicle or falling from it. So if the truck was overloaded, top-heavy, improperly balanced, or the load was not secured properly, the loading company or shipper can be on the hook. Think about scenarios like a flatbed load that slides off in a turn, a trailer that rolls because the weight distribution was wrong, a dump truck that spills debris on the road, a reefer or box truck where freight shifts and the driver loses control. In these cases, you do not want the trucking company to point the finger at the cargo problems and then have nobody in the case who actually loaded the truck. Because if loading negligence caused or contributed to the crash, that party should share responsibility. Party number 5, a third-party maintenance or repair company. Trucking companies often outsource maintenance, and when maintenance is done wrong, people on Florida roads pay the price. Federal regulations require motor carriers to systematically inspect, repair, and maintain commercial motor vehicles and prohibit operating vehicles in an unsafe condition. Now, that duty can still lead back to the motor carrier, but if a separate maintenance company performs the work negligently, that shop can also be a defendant. Examples that show up in real cases: brake jobs done incorrectly, worn tires that are not replaced, improper repairs after prior damage, loose lug nuts, skipped inspections, using the wrong parts. Maintenance cases matter because they often explain crashes that did not make sense at first glance. A driver says, "I hit the brakes and nothing happened." The company says, "We maintain our fleet." The truth might be sitting in a repair invoice or a parts order. Why identifying all 5 parties changes everything. When people ask, why can't I just sue the driver? Here's the honest answer: because the truck accident damages can be enormous, and one defendant rarely tells the full story. Identifying all responsible parties does 3 things. It increases available insurance and assets, which matters when injuries are catastrophic. It forces the defense to stop hiding behind one person's mistake. It helps you prove fault more clearly by showing how the crash was caused step by step. It also prevents a common defense move: blame dilution. If multiple parties share fault, Florida's comparative negligence rules still apply. But the truth is easier to prove when you have the whole chain in the case. What you should do after a Florida truck accident. I'll keep this tight and practical. 1. Get medical care even if you feel okay. 2. Call law enforcement and get the report made. 3. Take photos of the vehicles, the trailer, the company names, DOT numbers, skid marks, debris, and the scene. 4. Get witness names and numbers. 5. Do not give a recorded statement to the trucking insurer before getting legal advice. 6. Talk to an experienced Florida truck accident lawyer quickly because trucking evidence can disappear and legal deadlines are shorter than most people realize. Florida statute of limitations for negligence cases is now 2 years in most cases. So waiting can destroy your claim even if you were clearly wronged. Now you know the 5 parties you can often sue in a Florida truck accident: the driver, the trucking company, the manufacturer or parts maker, the cargo loading company, and a maintenance provider. But there is one simple decision people make in the first days after a crash that can quietly tank a claim, even when the other driver is obviously at fault: reporting or not reporting the accident to your own insurance company. So the next video is, do I have to report my car accident to my insurance company if it wasn't my fault? Watch that now, because that one phone call or decision to stay silent can affect your benefits, your timeline, and your leverage. See you over there.